Dear landlord or letting agent, if you're watching this video, make sure you watch it to the end. If you don't, this could probably be the most expensive few minutes that could have saved you fines of £40,000 plus your property and your business. In this video, I'm going to reveal the biggest mistake most letting agents and landlords are making right now. Landlords, you may think you're a good landlord, but what you think and how an enforcement officer decides to bring civil penalties and fines against you are two very different things. Letting agents, even you are now being targeted. Keep watching and find out how and why. Let me start by unraveling why both landlords and agents are now an easy target for no-win, no-fee solicitors, for tenants who are being educated, and for tenants who no longer have to worry about Section 21 evictions. And last but not least, what your local authority already knows about you. Did you know that no-win, no-fee solicitors are targeting tenants right now? It's all over the social media, telling them, have you got a repair issue? You could be owed a rent repayment order of up to 24 months. You could get your landlord fined. Did you know that local authorities already know that you probably haven't had a Category 1 and Category 2 hazard risk assessment done on your property? They already know, because most landlords and agents don't even know what a Category 1 or Category 2 hazard actually is. And if you can't answer that question yourself, they already know the answer to. Do you know why landlords and agents are an easy target? Because I've given it to my agent isn't good enough anymore. Or has your agent actually had a Category 1 and Category 2 risk assessment survey carried out? Most haven't, because they don't know about it. So do you know that in many properties, tenants are unlawfully subletting or overcrowding because rents are so high? Right, the local authorities know this. And do you know what that can mean for you? In many cases, it can mean a breach of the terms of your buildings and landlord's insurance, and even the breach of the terms of your mortgage. Now, under the 2018 Fitness for Human Habitation Act, you cannot transfer that responsibility, your responsibility as a landlord, to somebody else. And if you're an agent, you're part of the management chain, collecting money on behalf of the landlord. You have a fiduciary duty too, which means trading standards, not just housing enforcement, can come after you directly. So why do you think they want to see your bank records? By the end of this video, you will know 13 superpowers that local authorities have just been given, and 13 super rights that tenants now have alongside them. So that's 26 things in total. Do you know what those 26 things are? And that most, and also what you'll find out is that most landlords and agents have never even heard of them. So stay with me. This is going to leave you seeing your properties completely differently. Now, tenants have super rights and the local authorities have superpowers. Now, before I go into the 13 local authority superpowers of landlords and agents and the 13 tenant superpowers and rights, I'm going to formally introduce myself, what sets me and my business apart from all others, jumping on those that are jumping on the Renters' Right Act bandwagon. So my name is Rev Jas Sira. I'm the founder of Angel Moves. I have over 30 years experience working in local authority housing. I work as a financial consultant, advising council housing teams on budget setting and policy setting structures, including many London boroughs as well as Birmingham, Coventry and Leicester. I've run my own letting agencies. My family have owned rental properties, so I've been a landlord too, and I've been a tenant. I've seen this from every single side. I'm trained in HHSRS, that is the Housing Health and Safety Rating System, which is the same training housing enforcement officers themselves receive. I've got a accountancy and law degree, so I understand how to read law, right? Even though I'm not a solicitor. I'm trained by CITFA, which is the Chartered Institute of Public Finance and Accountancy. I'm also ACCA trained, that is an Association of Chartered Certified Accountants, and I've completed the NRLAs, that is the National Residential Landlords Association Renters' Right Act training. But what I bring to you is something unique Right, now so before I kind of go into like more about myself, which you'll be able to discover this in other sections of the website, yeah, right. So here's one number that tells you something, that everything. The National Residential Landlords Association says landlords in England are now dealing with around 168 different legal rules, and by their own admission, when they publish this, which is some time ago, that number keeps growing. So here's the biggest trap I see landlords and agents falling into. It's not that they're doing something dishonest, it's that they genuinely don't know what a Category 1 or Category 2 hazard actually is. And they've never even heard of the 18 different legal frameworks and housing inspector, enforcement officer can use against them, right, in order to bring fines and penalties. Right? And here's the uncomfortable truth. The local authority councils already know what is going on. They didn't just have the resources and the funding or the manpower to prove who was at fault before. So it was quick and cheaper to issue an improvement notice and move on. That has now changed completely from the 27th of December 25. So let me break down what's changed. And here are the 13 superpowers local authorities have now been given over you, the landlord, and you, the agent. So number one, they have a legal duty to enforce. Not just a power, a duty. Number two, the power to enter business premises without prior notice. And if you do refuse, right, then they can come back with a warrant within 24 hours. Number three, the power to enter residential premises. Number four, the power to demand information from banks. Number five, the power to demand information from accountants. Number six, the power to demand information from client money protection schemes. Number seven, the power to demand information from any person connected to the lettings, by emails, text messages, tenants agreements, all of it. Number eight, civil penalties. No longer having to go to court, civil penalties of up to £7,000, right, per offence, that is, for a first or minor breach. That's per breach, by the way. Right. And number nine, civil penalties of up to £40,000, right, for serious or repeat breaches. That's per offence. Number 10, the alternative route of criminal prosecution with an unlimited fine. And that criminal prosecution, right, can lead to imprisonment. Number 11, the power to retain and reinvest the revenue from every fine they collect. And this is significant, right? The power to, and let me repeat that, the power to retain and reinvest the revenue from every fine they collect. Number 12, rent repayment orders extended to superior landlords and company directors, closing the rent-to-rent and company-let loophole. Number 13, rent repayment orders extended to cover new offences under the Act. And they've now also extended that to 24 months before it's 12 months. So 13 superpowers, and here's why the 11th one matters so much. Councils now can keep the money from their own fines to fund more enforcement. So one enforcement officer costs a council approximately £35,000 to £40,000 a year. So one decent sized fine, right, covers that entire salary. So we're seeing on a daily basis, right, fines of £30,000, £45,000, right, plus, right. So everything after that first fine is pure income. Right. So as enforcement teams grow and fines income grows with them, the cycle feeds itself. Right now, councils, right, are still catching up on staff, but as they do, more properties get looked at, not fewer. That's simply how the funding structure works. So the government has has actually placed a duty on them to make sure, right, that all properties are free of Category 1 and Category 2 risk hazards, right? And so later on we'll go into more detail. We're not going to be able to go into in this video, right? But later on our website you'll be able to see this, where we're giving you more information about this. That the Category 1 and Category 2 hazards are just the gateway. It's just the opening of enforcement, okay? And these investigations aren't limited to the named landlord. Anyone generally part of the management chain, the landlord, agent, whoever's responsible for the property condition can be brought into it. Trading standards can act not just enforcement officers. Here's something worth understanding properly. The government's own language talks about targeting rogue landlords, but read what actually that means in practice. You could be a genuinely good person running your property in good faith, but if it has category 1 or category 2 hazards in it, you fall into the same category because ignorance of the law isn't a defense. If you're taking rent from someone, you're running a business, and not knowing your obligations is treated the same as not meeting them. And remember, an incident that doesn't have to actually happen. If a category 1 hazard is there, the potential for serious harm is enough on its own. And again, right, you can book your free 30-minute consultation, right, where we will kind of go through all these things. I'm pretty certain there's going to be lots of questions which will be kind of running through your head right now and even later. Now, here's a mistake I hear constantly. People think that this only applies to social housing. It doesn't. These rules apply just as much to private landlords and agents and private lets. So, and because you have one, whether you've got one property or 50, standard tenancies, rent to rent, guaranteed rents, it doesn't matter. You're all now in the net. Right. Now, let me show you the other side of this. Here's the 13 super rights tenants have now been given. And you know, the thing is, it's not just super rights, they've also got superpowers over you, the landlord. So this is what, and agents as well. So number 1, rent repayment orders of up to 24 months of rent claim back through the tribunal, first tier tribunals. So no court needed. Number 2, the right to complain directly to the council, who now have a legal duty to investigate. Number 3, the right to trigger a category 1 or category 2 hazard investigation even without making a formal complaint. Number 4, the right to bring a disrepair claim used to block an eviction or back up a rent repayment claim. Number 5, access to no-win, no-fee firms already advertising directly to tenants online. And these, it's disgusting. These people, they're actually encouraging them. They're saying, look, you can make money out of this. And I'm horrified. It's happening right now. Right. So number 6, free access to the first tier tribunal, quicker and cheaper than court, and free for the tenant to use. So it's not going to cost the tenant nothing, it's going to cost you. Number 7, but the brand new Landlord Ombudsman with the power to make binding decisions. So they can bring complaints now straight to the Landlord Ombudsman. But so they will be able to do that. Number 8, protection against unlawful eviction, now a criminal offence since Section 21 was scrapped. So what is unlawful? Do you know what unlawful eviction is? So if you've got category 1 and category 2 hazards in your property, that becomes unlawful eviction. Number 9, the right to bring a discrimination claim. Number 10, the right to challenge a rent increase through the tribunal. So number 11, access to online tenant advice groups, teaching them every right they have. Number 12, access to AI tools such as ChatGPT, helping them spot hazards and quietly build a case before a landlord even knows or agent even knows, right, there's a problem. Number 13, the ability to gather evidence over months, photos, messages, dates. 13 superpowers, and there's more. And here's what makes this so dangerous for you. Every tenant is a good tenant until the day they're not. What flips that switch? Usually it's one or two things: rent increase that they're not happy about, or repairs that they have not been sorted quickly. And repairs is the big one because it connects straight back to those category 1 and category 2 hazards. A leak ignored for months, a window that won't shut, damp that keeps coming back to you. To you, it looks like a maintenance job on a list. To an inspector, it can be exactly what turns into a category 1 hazard and a £40,000 fine. And once a tenant feels ignored on repairs, that's the moment they go looking for advice from no-win-no-fee firms, from other tenants, from the council, from Citizen Advice Bureau, and from AI. None of them are doing anything wrong by telling the tenant their rights. But if you haven't sorted your property before that moment comes, that's exactly where you get caught out. Here's another angle most landlords never think about: trying to evict a tenant who's already raised repairs issues and they can claim it as its retaliation. Suddenly, you're the one having to prove otherwise, while they're treated as the victim of the process. With Section 21 gone, we're seeing more tenants come out of the woodworks and come forward more than ever, partly because no-win-no-fee firms are actively encouraging it, and partly because 24 months of rent repayback is a real money in terms of cost of living. Ask yourself an honest question: how many people would turn that down? So if you can get your money back for 24 months of rent, how many people are going to turn that down? They're not very few. So let me ask you something. Do you actually know what a Category 1 hazard is? How many there are? Category 1 hazards are not optional. No argument. Category 2 hazards are called initial or minor, but they're discretionary, which means it comes down to whatever officer is standing in the property on the day. That's exactly why enforcement differs from council to council, from officer to officer, and they can still carry a fine. That's down to the discretion of the officer. So here's a real example first. Now let me go back to the HHSRS training I did. We were told inspectors also carry a moral duty. If something doesn't look right to them, they can act on it there and then. Ask your head office, your legal team, your agent, which of those 18 legal frameworks applies to your property. Most won't be able to answer it. Can AI? No. And here's the part that really catches people out. Nobody has to get hurt, and nothing even has to go wrong for you to be fined. The whole system is based on risk, how likely something is, how likely something is, and how bad it would be if it happened. That's why the small stuff matters so much. Lino lifting up in the bathroom, sealant peeling around the bath, and a recent refurbish doesn't protect you either. If the property's over 15 years, there's almost always something to find. You're not trained to spot this. Neither is your agent. Neither is your head office. It was simply never your job. It's ours. Spotting these hazards is a specialist skill, completely separate from legal training. Your solicitor almost certainly wasn't trained to walk around a property and spot a hazard. That was never their job either. Same with your head office. Same with most compliance teams. And how exactly is your solicitor meant to defend you against a civil penalty anyway? These don't even go through court. It costs the tenant nothing to bring a case to a first-tier tribunal. Now let's talk money. A rent repayment order over 24 months on a property that's earning £2,500 a month is £60,000, and a civil penalty of up to £40,000. Add the legal costs. I think you're looking at over £100,000 just there. For some landlords, all of that together can run into £100,000 or more. Before you even set foot into a tribunal room, and breaching the hazard rules can also mean breaching the 2018 Fitness for Human Habitation Act at the same time. One hazard, two legal problems, right? And so now later on we'll go into more depth as well. So there's other videos on the site which kind of go into more depth onto this, right? And that's here I can't do everything. I want to be completely straight with you. We can't promise you'll never be fined. Nobody can do that. What we can do is cut that risk down massively by finding and fixing problems before an inspector ever sees them. And a proper risk assessment on file shows an officer that they're dealing with someone who's taking this seriously. In most cases, that means an improvement notice and a fair time frame rather than a fine. So why us? Through our existing free tenant placement scheme, we work with over 80 local authorities. We deal with housing inspectors and enforcement officers every single day. We make it our business to know how enforcement is actually changing, council by council. That's not something your head office, your legal team, or a generic website can give you. As a reverend, I don't see this as just as a business. If you're a landlord, this is your pension, your retirement, maybe your children's inheritance. If you're an agent, this is your business you built with your own hands, and it puts every landlord in our network at risk if not sorted properly. I take that seriously, and I'll be straight. This isn't a charity that money, but our training, our risk assessment surveys, and everything else we offer, which you'll see on our website, costs a fraction of what a solicitor or a drawn-out enforcement case would cost you. Becoming a free Angel Moves member keeps you updated on enforcement activity in your Pacific area, because that information doesn't stand still. Here's what your 30 minutes consultation covers. Number 1, protecting yourself from fines and penalties up to £40,000. Number 2, protecting yourself from no-win, no-fee firms simply by being compliant. Number 3, protecting yourself in tenant situations now that Section 21 has gone. Number 4, exactly where your real risks lie, right? It sits in the law already in force today. So we'll be able to bring this and inform you of this in the free consultations as well. So prevention really is better than the cure. Take a few minutes to look through the website. Email us any questions beforehand so we can prepare properly, so you can get the most out of your 30 minutes. I run this business God's way, not man's way. What we're bringing you here isn't a sales pitch, for it's what is real. So here's what to do right now. Book your Category 1, Category 2 risk assessment survey without delay. If you do have questions, which I'm sure you will, book your free 30-minute consultation. Email us and submit all your queries during the booking process. Or if there are questions, which I'm sure there will be, please email us in advance so you can take full advantage of the free 30 minutes. We have also paid consultation service if you do use up your free 30 minutes, right? We can't bring everything that you need to know in this one video. So take the time to navigate around our website, which has got some very useful information that you need to know and different services that we offer. Become a free Angel Moves member, right? So we can bring the enforcement policy and activities that they are planning to bring against you, and information your head office or ChatGPT can't bring to you, but we can.